This video will give you a brief overview of the steps involved in appealing a case to the Minnesota Court of Appeals. Throughout this video, we will be referring to the Minnesota Rules of Appellate Procedure. You can find the rules online at the website on the screen and in the video description. We will also be referring to our appeals guide, which has links to statutes, rules, forms, and other helpful resources for each stage of the process. You can find the appeals guide at the website on the screen and in the video description. There are different procedures depending on what kind of case you are appealing. This video will cover the general process, but you will need to talk to a lawyer if you have questions about your specific case. The State Law Library offers an appeals self-help clinic on the third Thursday of each month. You can find more information about the clinic and make an appointment at the website on the screen and in the video description. What is an appeal? An appeal is a legal term for asking an appellate court to review a judge's decision for legal mistakes. Most appeals do not focus on whether the judge correctly decided the facts in a case, but instead whether the judge correctly applied the law. Just because you are unhappy with the decision does not mean that it is legally wrong. In Minnesota, most appeals start at the Minnesota Court of Appeals. There are 5 general stages of an appeal. They are starting an appeal, transcript and record preparation, briefing, non-oral conference or oral arguments, and decision. This video will look at each step individually. You might find it helpful to follow along on our appeals guide. If you decide to file an appeal, you must file and serve your initial paperwork before your deadline to appeal. Rule 104.01 provides a general deadline of 60 days, but there are exceptions for certain case types. For example, if you are appealing an eviction case, you have 15 days to appeal. If you are appealing a decision of an unemployment law judge, you have 45 days, and if you are appealing a child protection case, you have 20 days. You can find links to the statutes and rules about deadlines on our appeals guide. It is important to figure out your deadline as soon as possible because Rule 126 says the court can't extend your deadline to appeal. If you aren't sure what your deadline is, you should talk to a lawyer. Next, find the forms you need to start your appeal. The forms you will need depend on the type of case you have. Many people appeal decisions from the district court. This would include case types like family, civil, criminal, housing, and probate. For these types of cases, you will need to file a notice of appeal and statement of the case. The Court of Appeals publishes form packets for certain types of cases. There are packets for eviction appeals, family law appeals, and post-conviction appeals. You can also find the notice of appeal and statement of the case as individual forms. We won't discuss these forms in detail because we have a separate video on filing a civil appeal that goes through these forms step by step. You will need different forms if you want to appeal an administrative case, such as an unemployment decision, a decision by a government agency like the Department of Human Services or a health licensing board, or a decision of a city, town, or county. For these types of cases, you will need to file a petition for writ of certiorari, a writ of certiorari, and a statement of the case. The Court of Appeals publishes form packets for administrative appeals and unemployment appeals. You can also find the petition, writ, and statement of the case as individual forms. We won't discuss these forms in detail because we have a separate video on filing an unemployment appeal that goes through these forms step by step. You will need to file and serve your appeal before your deadline. Filing means giving your documents to the Office of the Clerk of Appellate Courts. You have 3 options for filing your appeal with the Clerk of Appellate Courts: by hand-delivering the documents in person, by mail, or by e-filing. Choose the method that works best for you. You will also need to pay a filing fee when you file your appeal. The filing fee for starting an appeal is $550. If you cannot afford the filing fee, you can ask the court to waive the fees. The court will consider your financial situation and may waive or reduce the fees. The court publishes a fee waiver forms packet you can use to make this request. You can find links to these forms on our appeals guide. Service means giving a copy of all documents you file to the other parties in your case. The most common way people representing themselves serve documents is by mail. You will need to send a copy of every document you file to the other party. You should also send a copy of the notice of appeal to the district court where your case was heard. You will need to file with the court a certificate of service, which proves to the court you served the other parties. Copies of this form are available on the court's website or on our appeals guide. Remember, service must be completed before your deadline or your appeal will be dismissed as late. After you have filed your appeal, the next stage is transcript and record preparation. The record is the term used for the evidence presented to the trial court. The Court of Appeals will not consider evidence that was not presented to the trial judge, so the record is the only evidence the judge can review when deciding your appeal. The trial court or agency that heard your case is responsible for sending copies of the documents filed in your case to the Court of Appeals. The record might also include a transcript of the hearing or trial. A transcript is a typed copy of what all of the witnesses, parties, and the judge said at your hearing. If you want to refer to a transcript, you will need to contact the court reporter from your hearing or trial and ask them to prepare one. Transcripts are not automatically created, and there likely will be a cost. If you cannot afford the cost of the transcript, the court may agree to waive the fee. You can ask for this using the same fee waiver forms you used when filing your appeal. To request a transcript, you will need to contact the court reporter for the hearing. If you do not know who the court reporter was, you can contact court administration in the county where your hearing took place. If your hearing was in Hennepin County or Ramsey County, there are forms you can use to request the transcript. You do not need a specific form in other counties, but you can refer to these forms to see the types of information you may need to provide. The transcript forms are available on our appeals guide. After you request the transcript, you will need to work with the court reporter to fill out and file the certificate as to transcript. This form tells the Court of Appeals that you have requested the transcript and will pay the court reporter, unless a judge has granted a fee waiver for this cost. The court reporter will prepare the transcript. This process can sometimes take several weeks. Once the transcript is complete, the court reporter will send you a copy and file the transcript with the court. Once the transcript is filed with the court, you will have 30 days to write, file, and serve your appellate brief. A brief is the term used for the written argument you present to the judge. If you are not represented by a lawyer, this is your only chance to tell the court why you think the decision you are appealing is wrong. Most people who are representing themselves file an informal brief. We have a separate video tutorial on how to put together an informal appellate brief, so this video will not go into detail about this step. You can find the informal appellate briefs video on our appeals guide. After the briefing period is over, the Court of Appeals will consider the case and make a decision. Judges on the Court of Appeals hear cases in panels of 3 judges. They will review the record and the parties' briefs, and then meet for either oral arguments or for a non-oral conference. Oral arguments are only granted when both parties in a case have lawyers. If you are representing yourself, you will not have an oral argument. Instead, the panel of judges will consider the case based on the briefs filed in your case. The court will set a date when this conference occurs. The conferences are not public, so you will not be able to attend. The final stage of an appeal is the decision stage. The Court of Appeals panel must issue a written decision in your case, called an opinion. In most cases, the Court of Appeals has 90 days from the date of oral arguments or the non-oral conference to release this decision. The court will send you a copy of the opinion in your case. The opinion will include the court's decision on the issues you presented to the court. It will also include the reasoning behind the decision, as supported by the record and by Minnesota law. There are several possible outcomes when the Court of Appeals reviews a decision. They may affirm the lower court's decision, which means that the court did not find any reversible or major errors, and the order or judgment you appealed is still in place. They may reverse the lower court's decision, which means that they do not agree with the decision reached in the trial court. They may also remand the case or send it back to the district court with instructions on how to decide the issue. When more than one issue is presented in an appeal, the Court of Appeals can also affirm some of the trial court's decision and reverse others. If you are not sure what the opinion in your appeal means, you should speak to a lawyer. Court of Appeals opinions are public information and are made available online. This means that people may be able to find the opinion when they search your name using Google or other search engines. After an opinion is filed, it cannot be removed from the internet. If you disagree with the court's decision, you may ask the Minnesota Supreme Court to review the decision. This can be a difficult, expensive, and often unsuccessful process. The Supreme Court only grants review in less than 10% of cases each year, and tends to take cases that involve statewide issues that will impact lots of different people. Appealing a case can be a time-consuming process. Because of the deadlines set by the appellate rules, most cases will take a minimum of 6 months from the time of filing your appeal to the time you get a decision from the Court of Appeals. The chart on this screen shows the estimated time for each stage of the process. Remember that the State Law Library has resources available to help you with your appeal, like our Appeals Subject Guide and our Appeals Self-Help Clinics. More information is available at mn.gov/law-library, or you can contact the reference desk at askalibrarian@courts.state.mn.us or 651-297-7651.